Right, good evening, everyone. That's 4:15, so I think we can get started. It's my very great pleasure to introduce Professor Kent Roach, who is Professor of Law at the Faculty of Law at the University of Toronto. He asked me to keep this introduction short. It's very difficult with a record such as Professor Roach's. Amongst other marks of distinction in a career as an academic, but also as an advocate, he has received a Trudeau Fellowship, he's a member of the Order of Canada, and he's won the Molson Prize for Social Sciences and Humanities. I'd love to pretend that I know what those are, but they all sound very impressive, so well done. He is the co-founder of the Canadian Registry of Wrongful Convictions, and as far as I can discern, the author or co-author of 17 books, including, and I should advertise it, this book, Wrongfully Convicted, Guilty Pleas, Imagined Crimes, and What Canada Must Do to Safeguard Justice. That book was published this year, and I'm certainly looking very forward to diving into it. Professor Roach's topic today is compensating miscarriages of justice, and the plan is that he speaks for around 45 minutes, and then we'll have a Q&A session, and then there will be drinks available outside at the end. So please feel free to stick around and have a chat around the edges of the seminar as well. I should explain that the presentation is being recorded. The Q&A session, if I remember to turn the recording off, it will not be recorded, otherwise it will be completely obliterated. So do not worry in the Q&A session about what you're asking. Okay, thank you. Professor Roach.
Well, thank you very much, Finlay, for that very kind introduction and for organizing this seminar. And thank you to the Center and the law faculty at Cambridge. This is a great pleasure for me. My topic tonight is compensating miscarriages of justice. This is an article that, based on an article that is forthcoming in the Columbia Journal of Transnational Law. But it's part of a larger work that is under contract with the press here on comparative miscarriages of justice. The tentative title is Justice for Some, Comparative, and then we kind of get into a problem. As you may know, in North America, we generally talk about wrongful convictions, whereas in here in England and internationally, the term is often miscarriages of justice. And I've always started my course on wrongful convictions, which, being North American or Canadian, I tend to be more comfortable with, talking about this definitional issue. And one of the things I try to do in this article is to drill down on three different possible things that we are compensating or things that we are studying. One is miscarriages of justice. The second is wrongful convictions, and the third is proven innocence. And they're all, I would submit, different. But miscarriage of justice is the broadest of the term, and I think subsumes wrongful convictions and proven innocence, but is not exclusively defined by them. So the starting point here is obviously Clive Walker's important but controversial definitions of miscarriage of justice. And Clive basically defines a miscarriage of justice as any law or practice that violates rights or fails to proportionately advance rights. And I have to say that I've been around the bush on what I think about Professor Walker's definition and changed my mind several times. there's a lot that's appealing to it from a normative perspective. And I think that Professor Walker's definition was probably very much influenced by his experience as a leading scholar of anti-terrorism law. And so I think, looking back at the Troubles, that was one thing that pushed him away from looking simply at wrongful convictions, and also to include unjust laws and even practices that violate the rights of the crime victim. But as a number of commentators, including Professors Nobles and Schiff, have said, it may not be all that useful when you're actually talking about wrongful convictions or even trying to write a book about that. So we'll leave Professor Walker's broad definition aside for a moment, and then look at where the term miscarriage of justice originates. And of course, in 1907, in the Court of Appeal Act, that was the main ground of appeal. Appeal courts, and of course that continues to be the case in many of the former colonies, Canada, most parts of Australia, and New Zealand. And appeal courts, I think, are understandably reluctant to have a comprehensive definition of a miscarriage of justice. So most appeal courts, but going by the case-by-case method, will say a miscarriage of justice can include an unfair trial, but can also include cases where a conviction is, in present English terms, no longer safe because of new evidence or other concerns. The other use of miscarriage of justice is obviously in Article 14.6 of the International Covenant of Civil and Political Rights, and in your Section 133 of the Criminal Justice Act 1988. And of course, as this audience knows only too well, the UK Supreme Court has disagreed and killed lots of trees over the meaning of a miscarriage of justice in terms of compensation under the Criminal Justice Act 1988, which was enacted in order to make clear that there was compliance with the International Covenant on Civil and Political Rights, as well as a protocol to the European Convention in much the same terms. So that the term miscarriage of justice is used in the English legislation, mirroring the covenant, although it's always been tied to what I have to say is the somewhat strange notion for a criminal lawyer that in order to achieve compensation, the applicant must prove beyond a reasonable doubt that they are a victim of a miscarriage of justice. So for a criminal lawyer, or at least a relatively traditional and aging criminal lawyer such as myself, the idea that the individual would ever have to prove anything beyond a reasonable doubt seems to me to be a stretch, if not an absurdity. That, in my view, that is a special standard that we can only expect the state to discharge, and is very much tied to the presumption of innocence and the need for restraint in the use of the criminal code. But really, from the beginning, and Professor Quirk knows this better than I as leading commentator on this issue, the UK highest court has disagreed on its meaning. So in Mullen, the court was, I think, somewhat disappointingly, in my view, agreed that Mr. Mullen, although he was more or less a victim of extraordinary rendition, would not qualify for compensation because he may very well have been guilty of the terrorism offenses with which he was charged. But there was a disagreement with Lord Stein. I hope that's the right pronunciation. Stein, okay. Well, no, that's what happens when you cross the pond. Although I mispronounce everything in Canada too. So anyway. So he very consistently said you have to be innocent. Lord Bingham said no. It could also expand a little bit, but obviously not as far as to cover Mr. Mullen's situation. There was refinement and continued disagreement in Adams. And then most recently in Hallam, which is now under reserve by the Grand Chamber in Strasbourg. And, I expect that some of the questions will revolve around what the Grand Chamber might decide. I'd be very interested in your views. I was finally able to watch the oral argument in the Hallam case, but I really couldn't, sometimes when I watch the oral arguments in North America, I kind of know where the court's going, or at least I think I know where the court's going, but I couldn't really figure that out. So miscarriage of justice is a somewhat vague term. It has an unsettled meaning. But why is it used? Well, here I come back to what Professors Noble and Schiff used in their excellent monograph, Understanding Miscarriages of Justice. And also, this article is dedicated to Guido Calabresi, who was a teacher of mine and has very much influenced my scholarship and has been a wonderful mentor to me throughout the years. And I think one way of looking at the disagreements and slippage over the meaning of a miscarriage of justice vis-a-vis wrongful convictions, vis-a-vis proven innocence, is that these terms are being used to finesse and even disguise a tragic choice between full justice and compensation and the rationing of funds. So much like Professors Noble and Schiff said that, when the Court of Appeal, the CCRC, are engaging in a kind of tragic choice, disguised analysis between a sense of justice, the promise that the criminal justice system makes that no innocent person will be or should be convicted and punished, and other often unstated implicit concerns about efficiency, costs, and the like. I think even more directly, when it comes to compensation, you do have this kind of implicit rationing of justice. And, in the course of trying to write a book about comparative miscarriages of justice, I was quite heartened to see that Calabresi and Bobbitt use comparative law as a means to illustrate their approach to tragic choices. So, a central issue in tragic choices is how do societies allocate scarce resources such as kidneys for kidney transplants? And Calabresi and Bobbitt use the examples of the United States and England and, as always, for Guido, Italy, as an example of different ways that ration choices. And they come to the conclusion, which is maybe I think counter to Dean Calabresi's reputation as a law and economics scholar, that there is no one right way to ration scarce resources and to navigate each society's tragic choice. And that they say this will differ from society to society. They look to the English model as one at the time in 1978 that was based more on deference to clinical judgment, deference to elites, compared to the American model. But they make clear that societies will change the way that they conserve scarce resources over time. And of course, given the changes, the regrettable changes to the English compensation scheme, which I will discuss, the abolition of ex gratia compensation in 2006, the capping of damages in 2008, and then the requirement of an innocence finding or an innocence requirement in 2014, this I think fits with Calabresi and Bobbitt's way to conceive of this kind of evolution in the allocation of scarce resources. So that's miscarriage of justice. Wrongful convictions, culturally, is used more often in North America, but I think really fits 14.6 more than, it's called miscarriage of justice, but if you read 14.6, it requires a conviction by a final decision. And in the course of my article, I've gone into the travaux préparatoire, and 14.6 was one of the most controversial provisions in the ICCPR. Much more controversial than Article 9.5, which provides a right to compensation for all unlawful arrests and detention. So the Americans originally opposed the inclusion of 14.6. Eleanor Roosevelt, who was leading the delegation, said this doesn't belong in an international Bill of Rights. Of course, she had just worked on the Universal Declaration. So the Americans tried to get it removed. The UK delegation tried to get it removed. The Americans, when they couldn't get it removed, added something where the applicant, in order to receive compensation, would have to prove that he or she was not responsible for their wrongful conviction. This is particularly for Professor Spencer, who is watching remotely. It was, I believe, France and one other country escapes me, that said, no, you can't do that because that infringes the presumption of innocence. And so so 14.6 was amended in its drafting to remove the requirement that the complainant prove that he or she was not responsible for their wrongful conviction. So it's still that principle of being disqualified for compensation because of contributory negligence or fault is still in there, but the presumption placed upon the accused or the applicant has been removed. So 14.6 has a lot of internal restrictions. There has to be a final decision. So that was added, I believe, at the request of the UK, so that they didn't want compensation when a person's conviction is overturned through an ordinary course of appeal. That may also be seen as a kind of tragic choice, limiting scarce resources. But of course, other legal systems do recognize a right to receive compensation if you are acquitted on appeal. Indeed, other countries have long recognized a right to compensation for pretrial detention that ends in an acquittal at trial. So a kind of, something that in the ICCPR's terms would be covered under Article 9.9.5. So 14.6 is really quite restrictive, has to be a final decision, has to be a new or newly discovered fact that conclusively reveals that there is a miscarriage of justice, and the non-disclosure of that fact has to not be proven to be the fault of the applicant for compensation. So it is, I think, quite a restrictive provision. And of course, this was drafted in the 1950s. The ICCPR isn't available for signing until, I believe, it's 1966. But this raises an issue, one that Guido Calabresi has dealt with in A Common Law for the Age of Statutes, of what do you do with the obsolescence of human rights? So most of our human rights were developed in the immediate post-World War II era. Well, they're getting kind of old. And I think they're getting particularly old in the wrongful conviction context, because much work has identified, and of course you're living through this with the post office scandal, that a lot of miscarriages of justice happen because of false guilty pleas. Perhaps false guilty pleas that are rationally made by an accused who is outmatched by the prosecution. Also false confessions. And so, one of the side themes in the article that may be of interest is, what do you do with out-of-date human rights instruments? And as a sign of 14.6 perhaps being out of date, if you look at Article 85.3 of the Rome Statute, you will see that Article 85 codifies 9.5 and 14.6 of the ICCPR in its first two subheadings. But Article 85.3 adds something new, which allows for the award of compensation to an accused before the ICC if there is a serious and manifest miscarriage of justice. So that's a kind of updating. And that, responds to the fact that, maybe someone deserves a compensation even though they were not convicted by a final decision. Or maybe they deserve compensation even though they made a false confession under duress, or perhaps even a false guilty plea under very, very difficult circumstances. And of course, the Calabresi's approach, and I share this, as does Professor Young, in her work on dialogue, is, maybe, or perhaps I shouldn't speak for Allison, I'll just speak for myself, but I want to acknowledge that you're here, the Calabresi approach is courts can play a role in updating old statutes, right? So, I mean, to the extent that dialogic review is not simply an invention of the Canadian Charter, it actually, in my view, describes common law constitutionalism. And, crucial to Dean Calabresi's approach is that even if there is a so-called activist judicial decision that updates an old statute, one, the counter-majoritarian objection to active judicial interpretation is less because it's an old statute. And two, what it does is it sets the burden of legislative inertia. And, it is not impossible for the legislator to, especially when you're talking about statutory interpretation or Section 3 or of the Human Rights Act, for the legislature to clarify, no, what the judge thought was an obsolete statute is actually one that the current legislature supports, so that there's a degree of pushback. But of course, when you're dealing with supranational rights instruments, you can't really do that, right? And so there have been some attempts by dissenters, including Martin Sheehan in the UN Human Rights Commission, to basically read out the idea that you have to have a conclusive evidence that there was a miscarriage of justice. Sheehan has tried in dissent, I believe, to read that as only applying to the reference to pardons as opposed to judicial decisions in Article 14.6. And to me, at least, that strikes me as a very Calabresian sort of way. But I do recognize that it's different because, given the state of the world and the nature of trying to amend human rights instruments, the burden of legislative inertia, such as it is pretty extreme. So I think it is an interesting question whether we were redrafting 14.6, would it be the same? And there's been a lot of learning about miscarriages of justice and wrongful convictions, and I would suggest false guilty pleas and false confessions would, if we were starting anew, be taken into account. The last thing I want to say at this stage about this is, on the one hand, all of the internal restrictions on 14.6 make it look rather stingy and mean-spirited. But in my kind of survey of national implementations, I found far more examples of national laws that implement 14.6. One example is the Act, the Australian Territories Charter of Rights and Freedoms, obviously your 1988 legislation. Then in Article 9.5, which says you have a right to be compensated for all unlawful arrests and detention. No internal qualifications except the word unlawful. And there, if you look for national legislation implementing Article 9.5, you're not going to find it. I don't think it exists in this country. It doesn't exist in the United States, except in the state of West Virginia, Why West Virginia? I'm not really sure, but there is legislation in West Virginia. The Chinese state compensation law can apply to that. And again, if you look at this through tragic choices, through a tragic choice lens, you could say, or even a remedial equilibration lens, as Darrell Levinson has talked about, you could say, well, maybe it's explainable that more countries have signed up to have legislation to implement 14.6 because it is more manageable and less costly than implementing Article 9.5. Now, the Italians do have legislation that applies to pretrial detention that ends in an acquittal. And the Italian data suggests that it's far more expensive to pay to implement Article 9.5, that is, pretrial detention that ends in an acquittal, than it is to implement Article 14.6, because the Italians, perhaps not known for their statistics, actually have some of the best statistics in this area, and they keep track of how many euros they spend. And they spend a lot more paying for wrongful pretrial detention. Again, with a bow to Professor Spencer, that also, kind of puts maybe a different perspective, the sort of criticism of the Italian criminal justice system that certainly we saw in North America and in this country perhaps around the Amanda Knox case. So the third, and in my view, least favored a definition here is the idea of proven innocence. And it was proposed by Israel late in the drafting of Article 14.6. I have the actual words there. A person proved innocent of a crime that he had previously been convicted shall have a right to compensation, but that was rejected. Professor Majuzi from South Africa has an excellent article on this in 2019. And one of the things that I try to do in the article is to excavate the origins of the proven innocence approach. And it really is found in the work of the leading scholar, the kind of, the grandparent of all wrongful conviction scholarship in the United States, Edwin Borchett. And Edwin Borchett, in 1912, a long time ago, went over to Europe, and he was a very cosmopolitan, iconoclastic American scholar, spoke German and French, and he went over to Europe, and while he was working at the Library of Congress, did this very comprehensive analysis of European laws dealing with compensation for miscarriages of justice. And his findings were that many states at the time would compensate not only wrongful convictions, but pretrial detention that ended in an acquittal. And then he went back. He was a young man at the time, but an ambitious young man. And to borrow from Maximo Langer's, I think, very helpful term of translation as a metaphor as opposed to transplantation or migration of ideas, what Borchett did is he knew that compensating for unwarranted pretrial detention would be a non-starter with American legislatures. And so he proposed a proven innocent standard that was adopted in Wisconsin and California in 1913, was adopted in American federal legislation in 1938, which basically remains the same. And so the proven innocent innocence has succeeded. And, to go back to, say, someone like Michael Naughton, Professor Naughton would argue this represents a lay understanding of what a miscarriage of justice is. Now, I don't agree with Professor Naughton on the issue of miscarriage of justice, but I think he is correct when he says that's a lay and populist understanding. And so, Bobbitt, in 1932, wrote a book called Convicting the Innocent. And he said this is only about people who are clearly innocent. And of course, the idea of proven innocence in the United States has now subsequently been taken up by the Innocence Projects and has migrated from compensation law, which you might characterize as a form of civil or administrative law, into criminal law. And so in order to have defaulted habeas corpus relief in the United States, you have to prove innocence. You have to go through what the Americans call an innocent gateway. Now, again, and this goes back to Calabresi and Bobbitt, on the one hand, I don't like innocence standards, and I feel that there's something with them that's at odds with the presumption of innocence, but I also recognize that they have been extremely effective in the United States. I mean, the accomplishments of the Innocence Projects are nothing short of miraculous when you look at the reality of American mass imprisonment and anti-Black racism. I really think that Barry Scheck and Peter Neufeld should get a Nobel for what they have done. But I don't, and one of the reasons why I want to write the larger book is I don't necessarily think that's a model for Canada or the UK or Australia or India or so on. That's really one of the reasons why I want to write this book. And of course, Professor Spencer has also done some of this translation in that he has been very critical of the restrictions on compensation for miscarriages of justice in England, including the abolition of the ex gratia and so on, in part because he is familiar with the French approach, which is much more generous than the English approach, and has pointed out, I think, some of the hypocrisy of English views of the French criminal justice system, at least when it comes to this particular corner of it. So, on the one hand, I understand why the Americans have taken a proven innocence approach. I respect the success that it has had. But on the other hand, normatively, I do feel that it is not the appropriate way to go, and I agree with Professor Quirk there. Now, in doing this research, I found the Nelson and Colorado decision from the U.S. Supreme Court, which is an extraordinary decision that I wasn't as familiar with, frankly, as I should have been before. Justice Ginsburg, the late Justice Ginsburg, for the majority, says that a Colorado statute that requires someone by clear and convincing evidence, which is usually the standard in American compensation laws to prove their innocence, violated due process. Why? Because it violated the presumption of innocence. Now, Nelson and Colorado was not about compensation. It was about collecting a kind of victim fine surcharge and court fee surcharge that was routinely attached to convictions. Now, maybe the Americans are going to, and they have so far, distinguished this from compensation schemes, but that's too fine a distinction for me. Now, one of the things that I would love to have your views on is if you read, and, I don't necessarily want to criticize her because I guess she's probably very close to a secular saint, but if you read Lady Hale's judgment in Adams, she kind of, very similar to Justice Ginsburg, says that a requirement to prove innocence would be a violation of a fundamental principle of criminal law, Wilmington, the Golden Thread et al. And so I really like Lady Hale's judgment in Adams, and I was kind of amazed to hear in Hallam, where she's in the majority that doesn't declare the 2014 to be incompatible, and she says Strasbourg will not declare this incompatible. She may be right as a matter of realpolitik, but I think her principles were right in Adams. And I find that kind of juxtaposition to be really quite interesting. So, the only way I think that you can justify a proven innocence, and maybe, frankly, any compensation scheme that places a burden on the applicant, is through this kind of formalistic criminal-civil distinction. But at least in Adams, per Lady Hale, and in Nelson and Colorado, per Justice Ginsburg, that easy and categorical distinction was not followed. Okay, so just because I do want to leave lots of time for questions. When I look at the implementation of Article 14.6 throughout the world, the UN Human Rights Committee in General Comment 32 says states should enact legislation. And indeed, in Dumont and Canada, the UN Human Rights Committee has found Canada in violation of both Article 14.6 and the right to an effective remedy because we don't have legislation. But again, to me, this raises a legal process issue of what are the comparative merits of legislation, admin, or civil litigation. In Canada, we've compensated about half of all of those 87 people who are on our registry of wrongful conviction. In the UK, you've compensated, I believe, 81 of the 465 that are on the Exeter site. The US, they've compensated about 2,000 out of the over 3,000 that are on the American registry. And Professor Gutman has illustrated, and the most recent figures are the Americans, you gotta love them, have paid almost $3 billion in civil rights judgments by juries to those who have been wrongfully convicted. Under statutes, which are available in 38 of the states, they've paid just under $1 billion. So, you have to admire, in some ways, the generosity of the American state. The UK and Canada are nowhere near close to paying $4 billion to the victims of miscarriages of justice, of which, almost 60% of those on the American registry are black. This is not inconsiderable, but it also demonstrates that you're going to get more money if you can bring a successful civil rights claim in litigation before the courts, damages decided by juries, then you will get under statutory regimes which are subject to qualifications, caps on damages, and so forth. So now, I've talked a lot about what my colleague Rand Herschel calls the World Series approach. So I've talked about the UK, I've talked about the US, I've occasionally mentioned Canada. But what really got me interested in this was the Law Commissions of India's 2018 report on wrongful prosecutions. And it was very interesting because the Law Commission of India did that report basically when it was directed by judges on the High Court of Delhi to do that report. Because what the judges in Delhi said was every day we see people being acquitted that have been detained before trial, often for years, in horrible conditions. Yes, they can bring litigation, but most of them are poor and otherwise disadvantaged. And we think the Law Commission should at least look at this issue. And so what I find interesting about the Law Commission of India's report is it says, yeah, look, we should implement 14.6, but we're not going to do it the American or the British way. That is, we're not going to require proven innocence. Why? Because we don't really use DNA as much in India, and we think that will be an unrealistic standard of proof. They also say it will violate the presumption of innocence. But they also recommend that there be compensation for pretrial detention that ends in an acquittal. Although they attach to that a kind of tragic choice requirement that in order to get that compensation, either for pretrial detention or wrongful conviction, that the applicant must establish malicious or bad faith prosecution. So there is a fault requirement that is arguably in violation of 14.6 and 9.5 of the ICCPR, but may be a not unreasonable tragic choice a device to allocate scarce resources in India. Now, that a report has not been implemented. It's been discussed in the Indian National Legislature, and the minister has, I think, very sensibly, for reasons that I will come to, said, we want to introduce this also with other bail reform, right? So that, the issue to the problem of pretrial detention is not just compensation. In fact, compensation alone is kind of a dubious remedy. They've also asked the Supreme Court to declare the Law Commission's proposal to be law, something I don't know if Professor Lewis thinks would be a good idea, or not. But even the Indian Supreme Court declined that invitation, as tempting as it might be. So India has not yet joined the ranks of countries that have a compensation for pretrial detention. Obviously, France, Germany, Italy, the Nordic countries are included, but also China. China's state compensation law, originally enacted in 1994, includes it. There's evidence, not so much on pretrial detention, but that China is paying its wrongfully convicted who are discovered more money now than it used to. But the last part of my paper says that simply paying compensation in Calabresi terms, treating the rights that are violated by miscarriages of justice as liability rules as opposed to property rules is not sufficient, and indeed can do a kind of miscarriage of justice washing. So I've borrowed here from greenwashing, and so the idea in China that we throw more money at those who have been able to prove that they're innocent and have been wrongfully convicted, while there are still pretty routine wrongful convictions, 99% conviction rates, and an unknown number of executions, to me, just kind of rings very hollow. And then the last thing, and this is the last thing that I say, and probably one of my reasons for wanting to write the book, is that in the end, I conclude that given all of these differences between miscarriages of justice, wrongful convictions, and proven innocence, that it would be a mistake to follow Brandon Garrett's proposal to recognize a new international right to claim innocence. Now, Professor Garrett is someone I know and I like and I respect, and he thinks I'm totally wrong. So you should take what I say with a grain of salt. Professor Garrett has, in many ways, he is today's Edwin Borchett. That is, he is the leading scholar of wrongful convictions. His seminal book is called Convicting the Innocent, just like Edwin Borchett's is, published in 2011 by Harvard. And it's a great book based on the first 250 DNA exonerations. And Professor Garrett has engaged, come over here, the other place, not here. I'm trying to win your favor, and has written an article in 2017 where he looks at, about 20 different jurisdictions, including China, including India, and say there is a consensus in all of these jurisdictions that an accused should have a post-conviction right to claim innocence, right? And he cites the CCRC as an example. And my problem with that is, yes, I guess the CCRC and, Professor Naughton would disagree, but, certainly if you're factually innocent, your conviction probably shouldn't be safe. But what he's doing, I think, is taking the lowest common denominator. That is proven innocence. So proven innocence is a miscarriage of justice, but there's lots of other things that are a miscarriage of justice or an unsafe conviction that don't amount to proven innocence. And so if there was a new international right to claim innocence, then I think, although that would be a victory in the U.S., where the U.S. Supreme Court has only flirted with this international right to claim innocence, it might fit the practice in China, but I think it would be regressive in this country. I think it would be regressive in our country. It would represent a kind of race to the bottom, or a race to a common denominator. So as much as I respect the accomplishments of the Innocence Projects and Professor Garrett, I think this would be wrong, and that's one of the reasons why I want to write the larger book that this article is a part of. So thank you very much for your attention, and I look forward to your questions.